Bring in our legal analyst, Kendall Coffey, former federal prosecutor, also the political director of Dream Defenders. That's the group that staged those protests at the Capitol and met with Governor Scott. Sarah Taylor Kendall is with us. Sarah, let me start off with you here. We heard, Kendall, we have you alone here. I'm sorry. Let's start off with you, Kendall, on this op-ed, for example, in the New York Times. It says in part, the headline was Second Thoughts on Neighborhood Watches, and it says that it was about Sanford and the shooting. It says Florida's laissez-faire gun culture epitomizes by the state's stand your ground law. Unlike traditional doctrine requiring a citizen to retreat from danger, gives a legally armed person dangerous leeway here. We know this hearing is about the discussion today, but do you believe that the stand your ground law gives that dangerous leeway that we've discussed so much since the Trayvon Martin shooting?
Well, absolutely it does. That's why the State Prosecutors Association has opposed stand your ground laws, which have in all too many cases become a license to kill, an invitation to stand and shoot. Now, at least there's a hearing today. Do we expect any possibility that the House is going to recommend repealing the law? No, but there can be changes made. And to say not changing one darn comma is a slogan. Right. It isn't a response to a serious problem, an experience that has told us that this law has gone far beyond what was originally intended in 2005.
And Kendall, again, I can't stress enough, you're a former federal prosecutor. What do you believe you see the flaws in this law that others, particularly those with the power to do something here with legislation, are not seeing?
Well, first of all, let's use some examples of what's happened with the law. People who have been shot in the back have nevertheless been pronounced, in effect, stand your ground cases. Drug dealers in a fatal shootout, they've been able to invoke stand your ground. What this law needs to get back to is self-defense where it's reasonably necessary and where somebody has a burden of avoiding killing somebody if they possibly can. The other thing that I hope happens, there's a bill in the state Senate which is a little bit of a compromise, and maybe there's hope for a compromise, and it says in effect, if you're the one that precipitated, that created the confrontation that turned out to be fatal, sounds a little bit like George Zimmerman, who went hunting for Trayvon Martin, we believe, then you can't claim stand your ground. And even though that's a compromise, it would be a big step forward.
Okay.